what I've told my clients is that they really need to go back and take a second look at their non-compete agreements. Anything over a year, they really need to amend that non-compete because it is highly unlikely in today's climate that a court will enforce any non-compete that restricts competition for more than a year.
Thank you for tuning in to Brach Eichler Talks, where we explore and discuss today's trending legal topics. My name is Joseph Cameron, and today I'm here with Brach Eichler member Rose Suriano. Rose is an experienced business litigation attorney representing both national and international companies in many industries, including manufacturing, financial services, technology, supply chain, and construction, to name a few. How are you doing, Rose?
Hey, Joe. Thanks for having me. I'm a partner, as you know, with Brach Eichler. I handle commercial litigation, and I've handled commercial litigation for over 30 years. I represent large national, international companies in a variety of business disputes, contract claims, but non-competes, which is what we're here to talk about today, has become front and center for a lot of companies in terms of protecting their confidential information. So I'd like to spend a few minutes talking about current trends with non-compete agreements.
I'm glad that you brought that up. I've been hearing a lot in the news about non-compete agreements and confidential information. So if you could expand upon that a bit and really explain to everybody what all of this news is about, that'd be great.
Sure. What's happening in the legal world with respect to non-compete agreements is, are they enforceable? Are courts going to continue to restrain an employee who leaves from a company from going to a competitor? Non-competes have been around for, 60, 70 years. And the purpose for a non-compete is for a company to be able to protect their confidential and proprietary information, such as customers, customer information, pricing. Because the last thing they want to do is to train an employee, spend significant time and resources giving that employee their confidential customer information, pricing, and that employee leaves and goes to a competitor and takes all that information with them. So what's out in the news is whether non-competes will continue to be enforced, because President Biden has indicated that he would like to see non-compete agreements abolished. And as a result of that, the Federal Trade Commission recently issued a proposed rulemaking concerning unfair methods of competition and clauses to restrict employment opportunities. And that's really a hot item right now that a lot of companies are looking at. The FTC, who is the Federal Trade Commission, is currently taking comments from the public, from employers, from companies, in terms of their position on the proposed rulemaking, which really will put a significant dent on non-competes and whether they are going to remain enforceable.
So what would you suggest to somebody who is currently working at a company and they did sign a non-compete agreement?
I usually represent the employer, but if I was going to be advising an employee who was leaving, I would tell that employee to make sure that the company that they go to understands that they have a non-compete agreement. Because if they do go to a new company and that company is a competitor, that company may likely be sued, as well as the employee, by the former employer. So it's important that there's full disclosure and that the employee work out the situation with the new company that he or she is going to. I would also tell that person to make sure that they have not taken any information from their prior employer, because what the former employer does is conduct a forensic investigation and will examine that person's laptop, their cell phone, computer records. All of that gets forensically investigated. And if there's any indication that the employee took information, that employee is likely to be sued by the former employer.
And you mentioned that you work closely with businesses. Is there anything that they should know or they should be aware of, or any way that they should prepare for any impending changes that are coming?
Yes. What I've told my clients is that they really need to go back and take a second look at their non-compete agreements. Anything over a year, they really need to amend that non-compete because it is highly unlikely in today's climate that a court will enforce any non-compete that restricts competition for more than a year. So that's number one. Assuming that the non-compete is enforceable, what I also tell my clients is to make sure that their agreements have what's called a non-solicitation agreement as well. And what a non-solicitation agreement is that an employee who leaves cannot solicit the former employer's clients. So that's an added protection that will protect the employer if the non-compete is found to be unenforceable. Another piece of advice I give my clients is that they need to take a look at their employment agreements to make sure that there is a confidentiality provision in that employment agreement, because that will protect their confidential information even if that employee goes to a competitor. If the employee who leaves goes to a competitor and that employee has a confidentiality agreement, they cannot disclose any of the information they learned from their prior employer. So a confidentiality agreement with a non-solicitation provision are pretty powerful to protect the employer's information, particularly where the current trend is to abolish non-compete provisions.
If any businesses have any questions about their non-compete agreements or any potential changes that they should make, how can they contact you?
Well, they can certainly contact me on LinkedIn. I have a pretty robust profile on LinkedIn with contact information. If anyone would like to contact me, they can also go to the Brach Eichler website for my contact information, or call me at 973-403-3129. Happy to walk through with anyone who has any concerns about their current non-compete agreements, what the current trends are, and what the likelihood of that non-compete agreement being enforceable is.
Thank you, Rose. It sounds like it'll be very helpful to a lot of businesses. Thank you for listening, and for more information, please visit bracheichler.com. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey. With over 80 attorneys, the firm is focused on the following practice areas: healthcare law, real estate, litigation, trust and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property and information technology, real estate tax appeals, tax, and cannabis law.